Just like that, we're halfway into your daily dose of business-related discussions on the Business Hour. Are you a small business owner? Well, the Employment Equity Amendment Act aimed at reducing the regulatory burden for smaller employers to allow them to focus on job creation came into effect on 1 January. We touched on the Employment Equity Act overhaul and what it means for small employers with legal analyst from Strata-g Labour Solutions, Mandilake. We usually speak to Advocate Dardius Vessels. You can listen to some of those chats with him up on ofm.co.za. But here's part 2 of my conversation with Mr. Nxana. How can small businesses balance the requirements of the Act with their operational constraints? I'm sure this is a question that a lot of small business owners would have. Constraints such as limited resources or a small workforce.
So now I think this is where actually now the benefit of this new legislation or rather amendments come in to intercede on behalf of these employees on that, of these employers on that, whereby previously some employers would have, issues about not being able to use their resources sufficiently. Now they've been given an opportunity to take those resources that they've been using either to find a strategy to help them to comply and channel those either in training and development. They can still promote, transformation or equitability in their workplace with those resources. But now the idea now is that those employers will not be obligated by law to actually comply with all of that. So that's the advantage that they will be having. So they means then that they have got now more resources. And remember, as I was saying, that they also had the obligation to align with the EAP and appoint, certain people in different occupational levels. So now they won't be required to do that at all.
What are the potential penalties for non-compliance with the updated Employment Equity Act, and how can small employers proactively mitigate the risks?
With small employers, fortunately, the penalty element of it will no longer apply to them because remember, they are no longer required to comply with employment equity. So the schedule in the Act, Schedule 1, that talks about penalties will no longer be applicable to them because they won't be submitting reports, they won't be preparing plans. However, if an employer finds themselves unfairly discriminating against an employee and that employee is actually sent to the CCMA or Labour Court for that matter, those courts, those platforms will actually now determine what will be the fine. But as it stands, there won't be fined or there won't be any penalties for not necessarily complying with the duties of a designated employer, even if that employer previously used to comply with those duties of a designated employer.
Thank you so much for your time. Where can business owners read up more information on the Employment Equity Amendment Act?
If you go to the Department of Labour in particular, they do have the Act actually published under their documents.
The Business Hour on OFM.
Thank you so much, Mandilake. Do you have any questions about that? You can email the questions to business@rfm.co.za. We'll do a follow-up. Again, that's business@rfm.co.za. We'll do a follow-up with the team at Strata-g Labour Solutions.
Businesses, let's talk business. Let's talk clean.